Hi, this is Tim calling from Senior Leads Boost with an important update about the change in Texas law recently regarding the sending of text messages by businesses. So here goes. So first of all, it's important to know that the new law change that I'll be talking about was signed into law on June 20th of this year, and it becomes effective on September 1st. Very short ramp-up time. So here's the summary of the amendment. Basically, it says that businesses that send text messages or SMS messages to or from Texas locations are subject to this law. There are some exemptions, but they're almost all ones that most small businesses will not be able to meet. For instance, publicly held companies are exempt. And there are severe penalties for non-compliance. So it's very important to know about this and to avoid violating this new set of rules. So what does it do? Basically, it says that marketing messages that are sent via SMS are subject to this new law. It also, by its wording, basically almost means that any kind of SMS message that is sent by a business could be considered a marketing message. So virtually it means really all text messages sent by businesses. It requires businesses that send messages to or from Texas, and their sending software providers, like our company, must register with the state of Texas and post a $10,000 bond, which might sound okay on the face of it, but in fact the registration form that you have to file is very complicated. It's also very intrusive. It requires significant amounts of business, operational, and personal information and banking account information and other things regarding the company and its officers. And then it requires quarterly updates to that registration data. So if you change or add new text messaging numbers, or if you bring on new sales personnel, you must report those updates every quarter. The penalties are severe. Number one, they can be up to $5,000 per each offending text message that you send. And what's actually almost more ominous is that enforcement can be brought via lawsuits by the government of Texas or by private citizens and their lawyers. So our concern is the net effect of this may be similar to what we've seen in some accessibility lawsuits brought by aggressive or opportunistic law firms against website owners with the goal of extracting large monetary settlements from relatively innocent defending companies in order to avoid unwinnable litigation. I won't use the word extortion. So what does all this mean? What this means is that for all intents and purposes, that companies that send text messages for business purposes to or from locations in Texas are probably going to be subject to this law. I'm not a lawyer. We are not a law firm. This is not legal advice. And you should check with your own law firm and also your own text messaging service provider for more information. Thanks for your time.